Part 2 of Legal Ethics. Q. Ginto filed an election case against Manlastas, which requires the revision of a number of ballot boxes. Judge Flores, who is handling the case, appointed a revision committee, which thereafter submitted its report to the court. Judge Flores then issued an order declaring the case submitted for decision despite Manalastas' objections and demands for a hearing. A complaint was thereafter filed against Judge Flores. Thereafter, the complainant withdrew his complaint. Should Judge Flores be held administratively liable even if the complainant already withdrew his complaint? Yes, Judge Flores is administratively liable. The withdrawal of the complaint or the execution of an affidavit of desistance does not automatically result in the dismissal of an administrative case. To condition an administrative action upon the will of the complainant, who for one reason or another condones a detestable act, would be to strip this court of its power to supervise and discipline erring members of the judiciary. The withdrawal of the complaints cannot divest the court of its jurisdiction, nor deprive of its power to determine the veracity of the charges made and to discipline, such as the results of this investigation may warrant. An erring respondent. Manalastas versus Judge Flores. Q. Does the dismissal or withdrawal of charges and the desistance of witnesses automatically result in the dismissal of an administrative case? No. The withdrawal of the complaint does not have the legal effect of automatically exonerating the respondent from any administrative disciplinary action. It does not operate to divest this court with jurisdiction to determine the truth behind the matter stated in the complaint. Furthermore, the need to maintain the faith and confidence of the people in the government and its agencies and instrumentalities should not be made to depend on the whims and caprices of the complainants, who are, in a real sense, only witnesses therein. Artemio Sabatin versus Judge Efrain Malari. Q. Montes is the accused in a criminal case for estafa, which is being heard by Judge Malari. Montes then filed a complaint against Judge Malari for allegedly conspiring with the complainant in the criminal case and having him arrested and jailed. The complaint filed by Montes was referred to an executive judge for investigation, report, and recommendation. The case was scheduled for hearing, but the notice thereof for Montes was returned unserved. According to the sheriff, Montes changed residence without leaving a forwarding address. The hearing of the case was reset to another date, but Montes again failed to appear. The executive judge recommended that as the complainant presented no evidence at all to substantiate the charges against Judge Malari, the complaint should be dismissed for lack of evidence. Thereafter, the office of the court administrator received a letter from Montes requesting that the executive judge be discharged as the investigating officer on the averment that he likewise instituted a complaint against the executive judge, but it was dismissed. Is there merit in the complaint? None. It must be stressed that in administrative proceedings, the complainant has the burden of proving the allegations in his complaint with substantial evidence. In the absence of evidence to the contrary, the presumption that the respondent has regularly performed his duties will prevail. Even in administrative cases, if a respondent judge should be disciplined for a grave offense, the evidence against him should be competent and should be derived from direct knowledge. In this case, the complainant failed to substantiate the charges he made against the respondent judge, let alone appear before the investigating magistrate to prove his allegations. While it is our duty to investigate and determine the truth behind every matter in complaints against judges and other court personnel, it is also our duty to see to it that they are protected and exonerated from baseless administrative charges. The court will not shirk from its responsibility of imposing discipline upon its magistrates, but neither will it hesitate to shield them from unfounded suits that serve to disrupt rather than promote the orderly administration of justice. Montes versus Judge Malari. Q. Attorney Sursagan was Nava's counsel for many years, but due to the lawyer's health condition, he withdrew as her counsel. However, Attorney Sursagan allegedly represented another client in a case against Nava. Attorney Sursagan is insisting that the attorney-client relationship between him and Nava had ceased and that his health incapacitated him from further performing his obligations. Should Attorney Sursagan be held liable for violating the Code of Professional Responsibility by representing clients with conflicting interests even if no formal investigation was made by the IBP? Yes. At the time respondent accepted his engagement as counsel for another client and filed a case against the complainant, he was still acting as counsel for the latter in a number of cases. In complaints for disbarment, a formal investigation is a mandatory requirement. The court may dispense with the normal referral to the Integrated Bar of the Philippines if the records are complete and the questions raised is simple. Similarly, if no further factual determination is necessary, the court may decide the case on the basis of the extensive pleadings on record. Complaints against lawyers for misconduct are normally addressed to the court. If at the outset the court finds a complaint to be clearly wanting in merit, it outrightly dismisses the case. If, however, the court deems it necessary that further inquiry should be made, such as when the matter could be resolved by merely evaluating the pleading submitted, a referral is made to the IBP for a formal investigation of the case during which the parties are accorded an opportunity to be heard. Mercedes Nava versus Attorney Benjamin Sorsogon. Q. A deed of sale covering a parcel of land located in Baguio was executed by Malectan and Elisa Fanget. The amount paid by the former was received by Elisa Fanget and deposited in the account of Attorney Artemio Bustamante, then counsel for the latter. It was found out later by Malectan that the land is subject to a controversy. When Attorney Bustamante refused to release the proceeds of the sale to Elisa Fanget, the latter, through her new counsel respondent, Attorney Colin, filed a complaint for rescission of contract. A compromise agreement was then executed wherein Malectan was not a signatory as she was in the United States at that time. The money was then transferred to the respective accounts as prayed for in the compromise settlement. Thereafter, Malectan filed a complaint charging Attorney Colin with violation of the lawyer's oath on the account that the lawyer knowingly caused the withdrawal from the bank of the purchase price of the lot in question, despite their knowledge of a defect in their client's right to claim the said amount. Does the lawyer have the right to apply the subject amount as payment of their professional fees despite the existence of a dispute on the legality of the amount? None. A lawyer may legally apply a client's funds in his profession to satisfy professional fees, which the client owes him, in the absence of any dispute as to the legality of the amount thereof. However, the fact that the lawyer has a lien for his fees and the client's money in his possession, or the circumstance that the client owes him more than the client's funds in his hands, may not excuse him from making an accounting, nor entitle him to unilaterally apply the client's money to satisfy his disputed claims. It is a settled principle that the compensation of a lawyer should be but a mere incident of the practice of law, the primary purpose of which is to render public service. The practice of law is a profession and not a money-making trade. As they are an indispensable part of the system of administering justice, attorneys must comply strictly with the oath of office and canons of professional ethics, a duty more than imperative during these critical times when strong and disturbing criticisms are hurled at the practice of law. Canon 1 of the Code of Professional Responsibility mandates all members of the bar to obey the laws of the land and promote respect for the law. Rule 101 of the Code specifically provides that a lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. A lawyer is expected at all times to uphold the integrity of the legal profession. Whenever it is made to appear that a lawyer is no longer worthy of the trust and confidence of the public, it becomes not only the right, but the duty of the court, which made him one of its officers and gave him the privilege of ministering within its bar, to withdraw the privilege. Mary Malikton versus Attorney Percival Pecas and Attorney Matthew Collins. Q. Cortes filed an administrative complaint against 3 justices claiming that the proceedings made before the Sandiganbayan were irregular, as it terminated the case without the defense having conducted a cross-examination on him to rebut the direct testimonies against the accused. Cortes also questioned the pronouncement made by the Sandiganbayan that he slept on his rights for failing to redeem the property in question within the 1-year period as required under the law. He avers that there was no need for him to redeem the property as the auction sale was not duly registered with the Register of Deeds of the province of Bataan, hence null and void, should the complaint filed by Cortes prosper. No, it must be stressed that as a matter of policy, the acts of a judge in his judicial capacity are not subject to disciplinary action. He cannot be subjected to liability, civil, criminal, or administrative, for any of his official acts, no matter how erroneous, as long as he acts in good faith. Only judicial errors tainted with fraud, dishonesty, gross ignorance, bad faith, or deliberate intent to do an injustice will be administratively sanctioned. To hold otherwise would be to render judicial office untenable, for no one called upon to try the facts or interpret the law in the process of administering justice can be infallible in his judgment. The provisions of Article 204 of the Revised Penal Code as to rendering knowingly unjust judgment refer to an individual judge who does so in any case submitted to him for decision and has no application to the members of a collegiate court such as the Sandiganbayan or its divisions who reach their conclusions in consultation and accordingly render their collective judgment after due deliberation. The remedy of the aggrieved party is not to file an administrative complaint against the judge, but to elevate the assailed decision or order to the higher court for review and correction. The administrative complaint is not an appropriate remedy where judicial recourse is still available, such as the motion for reconsideration, an appeal, or a petition for certiorari, unless the assailed order or decision is tainted with fraud, malice, or dishonesty. Leonidas Cortes versus Sandiganbayan Justices, Nimita Chico Nazario, et al. Q. A complaint was filed against Judge Pamintuan for ignorance of the law and arrogance. It was alleged that in 17 different cases, Judge Pamintuan had misapplied the indeterminate sentence law. Furthermore, complainants also alleged that Judge Pamintuan insults lawyers by means of intemperate and harsh words in the presence of litigants in public, and that he verbally assaults lawyers. Furthermore, he promulgated decisions with copies thereof, not readily released to the parties. Should Judge Pamintuan be disciplined administratively? Yes. The application of the indeterminate sentence law in the imposition of penalties in crimes punishable by the Revised Penal Code is a basic precept. Judge Pamintuan's repeated misapplication thereof in quite a number of criminal cases he had rendered constitutes gross ignorance of the law. A judge is presumed to know the law, and when the law is so elementary, not to be aware of it constitutes gross ignorance of the law. Indeed, judges are duty-bound to have more than a cursory acquaintance with laws and jurisprudence. Failure to follow basic legal commands constitutes gross ignorance of the law, from which no one may be excused, not even a judge. With regards to the other allegation, a judge should be courteous both in his conduct and in his language, especially to those appearing before him. He can hold counsels to a proper appreciation of their duties to the court, their clients, and the public without being petty, arbitrary, overbearing, or tyrannical. He should refrain from conduct that demeans his office, and remember always that courtesy begets courtesy. Above all, he must conduct himself in such a manner that he gives no reason for reproach. Clearly, the respondent judge has failed to observe courtesy and civility to the lawyers as well as the litigants who appeared before him. The court frowns upon the highly irregular practice of the respondent judge of promulgating a decision, copies of which were not then ready for release to the parties. The officers and members of the IBP Baguio Benguet chapter versus Fernando Pamintuan. Q. Should a judge be held administratively liable for ignorance of the law for granting bail to an accused in a criminal case without the requisite bail hearing, and despite the fact that there was an eyewitness to the murder who made a positive identification of the accused? Yes. It is already settled that when a judge grants bail to a person charged with a capital offense, or an offense punishable by reclusion perpetua or life imprisonment without conducting the required bail hearing, he is considered guilty of ignorance or incompetence, the gravity of which cannot be excused by a claim of good faith or excusable negligence. When a judge displays an utter unfamiliarity with the law and the rules, he erodes the confidence of the public in the courts. A judge owes the public and the court the duty to be proficient in the law and is expected to keep abreast of laws and prevailing jurisprudence. Ignorance of the law by a judge can easily be the mainspring of injustice. Jocelyn Gragida versus Judge Nieto, T. Transvalis. Q. Impang is the plaintiff in a case involving a collection of money with damages. Judge Del Rosario failed to decide on the case within the 90-day reglementary period. And even if after the lapse of 10 months, the judge had not yet resolved the case, should Judge Del Rosario be sanctioned administratively for his failure to resolve a case within the reglementary period? Yes. The failure of a judge to immediately resolve pending motions and to decide cases within the 90-day reglementary period constitutes gross inefficiency. Rule 305 of the Code of Judicial Conduct requires judges to dispose of the court's business promptly and to act one way or another on cases pending before him within the prescribed period. Therefore, undue delay in resolving a pending motion constitutes gross inefficiency. Delay results in undermining the people's faith in the judiciary and from whom the prompt hearing of their supplications is anticipated and expected. It reinforces in the mind of the litigants the impression that the wheels of justice grind ever so slowly. Certainly, undue delay cannot be countenanced at a time when the clogging of the court dockets is still the bane of the judiciary. Judges are expected to observe utmost diligence and dedication in the performance of their judicial functions and the discharge of their duties. Judge Del Rosario is meted with a fine in the amount of 10,000 pesos. Dolores Imbang versus Judge Deogracias Del Rosario. Q. Should a judge be disciplined for his failure to decide the election cases within the reglementary period? Yes. Judges should dispose of court business promptly within the period prescribed by law, or the extended time granted them by this court. This is mandated by Rule 305 of Canon 3 of the Code of Judicial Conduct, and by no less than the Constitution itself. Canon 6 reminds a judge to be prompt in disposing of all matters submitted to him or her, remembering that justice delayed is often justice denied. Delay in the disposition of cases erodes the faith and confidence of the public in the institution of justice, lowers its standards, and brings them into disrepute. Every judge must cultivate a capacity for quick decision. He must not delay the judgment which a party justly deserves. The public trust reposed in the judge's office imposes upon him the highest degree of responsibility to promptly administer justice. The court, however, is not unaware of the heavy caseload of judges and the rigors of travel that they sometimes have to make because of detail to vacate salas. It is precisely for this reason that the court has been sympathetic to requests for extensions of time within which to decide cases and resolve matters and incidents related thereto. Indeed, the court allows a certain degree of latitude to judges and grants them a reasonable extension of time to decide and resolve cases upon proper application by the judge concerned and on meritorious grounds. Romero Teodosio Rolando Rico versus Judge Arturo Carpio. Q. Does a judge's active participation during the hearing of the writ of preliminary injunction amount to an evident display of his bias and partiality in favor of the private respondents? And should he therefore disqualify himself from further hearing the civil case? No. Paragraph 2, Section 1 of Rule 137 Rules of Court provides that a judge may, in the exercise of his sound discretion, disqualify himself from sitting in case for just or valid reasons other than those mentioned in the said provision. But it does not give judges the unfettered discretion to decide whether to desist from hearing a case. The inhibition must be for just and valid reasons. The mere imputation of bias or partiality is not enough ground for them to inhibit, especially when the charge is without basis. Mere intervention of the respondent judge during the hearing of preliminary injunction by simply asking the materiality of a question directed upon the witness and ruling against the petitioners are within the prerogatives and powers of the judge. The fact that the judge asks questions in the course of the trial does not make him a biased judge. It is not only the right but also the duty of a trial judge to examine witnesses when it appears necessary for the elucidation of the record. A judge may also properly intervene in the presentation of evidence to expedite and prevent unnecessary waste of time and clarify obscure and incomplete details after the witness has given direct testimony. Mere suspicion of partiality is not enough. There should be a hard evidence to prove it, as well as a manifest showing of bias and partiality stemming from extrajudicial source or some other basis. In the absence of clear and convincing evidence to prove the charge, a ruling not to inhibit oneself cannot just be overturned. Furthermore, just because the opinion of a party is at variance with that of the judge, the former cannot use it as an excuse to hurt imputations of unfairness and partiality in the absence of clear and convincing proof. Spouses Leopoldo Hizon and Perlita de la Fuente versus spouses Gigi de la Fuente and Josephine Mangajas et al. Landmark decisions. Admission to the practice of law. The Supreme Court and the Philippine Bar have always tried to maintain a high standard for the legal profession, both in academic preparation and legal training, as well as in honesty and fair dealing. One of the ways of achieving this end is to admit to the practice only those persons who are known to be honest, possess good moral character, and show proficiency in the knowledge of the law by the standards set by this court by passing the bar examinations honestly and in the regular and usual manner. Consequently, any charge or insinuation of anomaly in the conduct of bar examinations of necessity is imbued with wide and general interest and material importance. In re investigation of Angel Paraso, 82 Field 230, December 3, 1948. Practice of law. The right to practice law proceeds not from the territorial boundaries of the licensing authority, but within the jurisdiction of the licensing authority. Petitioner has confused her license to practice law in the Philippines to include the courts of other jurisdiction located within the Philippine territory. The U.S. Naval Courts Martial are courts duly constituted and under the jurisdiction of the U.S. government. They are not extensions of Philippine courts. They function independently and are guided by their own rules of procedure. Fidela Vargas versus Kiel Klein, 142 Scra 232, June 6, 1986. Practice of law under modern conditions consists in no small part of work performed outside of any court and having no immediate relation to proceedings in court. It embraces conveyancing, the giving of legal advice on a large variety of subjects, and the preparation and execution of legal instruments covering an extensive field of business and trust relations and other affairs. Although these transactions may not directly connected with court proceedings, they are always subject to become involved in litigation. They require in many aspects a high degree of legal skill, a wide experience with men and affairs, and great capacity for adaptation to difficult and complex situations. These customary functions of an attorney or counselor at law bear an intimate relation to the administration of justice by the courts. No valid distinction, so far as concerns the question set forth in the order, can be drawn between that part of the work of the lawyer, which involves appearance in court, and that part which involves advice and drafting of instruments in his office. It is of importance to the welfare of the public that these manifold customary functions be performed by persons possessed of adequate learning and skill, of sound moral character, and acting at all times under the heavy trust obligations to clients which rest upon all attorneys. Cayetano versus Monsod, GR 100-113. Practice of law, Patent Office. Members of the Philippine Bar authorized to practice law and in good standing may practice the profession before the Patent Office for the reason that much of the business in said office involves the interpretation and determination of the scope and application of the patent law and other laws applicable, as well as the presentation of evidence to establish facts involved. That part of the functions of the patent director are judicial or quasi-judicial, so much so that appeals from his orders and decisions are under the law taken to the Supreme Court. Philippine Lawyers Association versus Agrava. Powers of Congress to regulate the bar. The Bar Flunkers Act of 1953 is not a legislation. It is a judgment promulgated by this court during the aforecited years affecting the bar candidates concerned. And although this court certainly can revoke this judgment even now, for justifiable reasons, it is no less certain that only this court and not the legislative nor executive department that may do so. Any attempt on the part of these departments would be a clear usurpation of its function, as is the case with the law in question. The ultimate power to grant license for the practice of law belongs exclusively to this court, and the law passed by Congress on the matter is of permissive character, or as other authorities say, merely to fix the minimum conditions for the license. In Rec Cananan 94 Phil 534. Lawyers in Government Service. The Code of Professional Responsibility applies to lawyers in government service in the discharge of their official tasks, Canon 6, just as the Code of Conduct and Ethical Standards for public officials requires public officials and employees to process documents and papers expeditiously and prohibits them from directly or indirectly having a financial or material interest in any transaction requiring the approval of their office, and likewise bars them from soliciting gifts or anything of monetary value in the course of any transaction which may be affected by the functions of their office. The Code of Professional Responsibility forbids a lawyer to engage in unlawful, dishonest, immoral, or deceitful conduct. Rule 101, Code of Professional Responsibility, or delay any man's cause for any corrupt motive or interest. Rule 103, Colantes versus Renam Miron, 200 Scra 584. Clerk of Court. There can be no question that personal differences and family problems are not lawful grounds and valid justification for the frequent absence of an employee in the public service. Pursuant to Civil Service Act PD number 807, frequent unauthorized absence are grounds for disciplinary action, and the court considers respondent's misconduct a dereliction of duty and therefore prejudicial to the public's service. Honorable Cesar Sanco versus Francisca Hidalgo, 84 squat 816. Legal profession versus business. A partnership for the practice of law cannot be likened to partnerships formed by other professionals or for business. A partnership for the practice of law is not a legal entity. It is a mere relationship or association for a particular purpose. It is not a partnership formed for the purpose of carrying on trade or business or of holding property. Thus, it has been stated that the use of a nom de plume, assumed or trade name in law practice, is improper. Nom de plume means pen name. Primary characteristics which distinguish the legal profession from business are: 1. A duty of public service of which the emolument is a byproduct and in which one may attain the highest eminence without making much money. 2. A relation as an officer of the court to the administration of justice involving thorough sincerity, integrity, and reliability. 3. A fiduciary relation to clients in the highest degree. 4. A relation to colleagues at the bar characterized by candor, fairness, and unwillingness to resort to current business methods of advertising and encroachment on their practice or dealing directly with their clients. In Re Sisip, July 30, 1979. Lawyer's signature in a pleading. A lawyer's signature in a pleading constitutes a certificate by him that, to the best of his knowledge, information, and belief, there is a good ground to support it, and that it is not interposed for delay. This rule imposes upon a lawyer the affirmative duty to check useless litigations, willful violations of which may be subject him to appropriate disciplinary action. Arambulu versus Perez. Code of Professional Responsibility. Advertising the legal profession. It is highly unethical for an attorney to advertise his talents or skill as a merchant advertises his wares. Law is a profession and not a trade. Under Canon 27 of the Code of Professional Ethics, the most worthy and effective advertisements possible, even for a young lawyer, is the establishment of a well-merited reputation for professional capacity and fidelity to trust. This cannot be forced, but must be the outcome of character and conduct. The Director of Religious Affairs versus Estanislao Bayut. Advertising. A lawyer, in making known his legal services, shall use only true, honest, fair, dignified, and objective information or statements of facts. He is not supposed to use or permit the use of any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualifications or legal services. Nor shall he pay or give something of value to representatives of the mass media in anticipation of, or in return for, publicity to attract legal business. Prior to the adoption of the Code of Professional Responsibility, the canons of professional ethics had also warned that lawyers should not resort to indirect advertisements for professional employment, such as furnishing or inspiring newspaper comments or procuring his photographs to be published in connection with causes in which the lawyer have been engaged or concerning the manner of the conduct, the magnitude of the interest involved, the importance, the lawyer's position, and all other self-laudatory claims. Ulip versus Legal Clinic. 223 Squad 378. Solicitation of cases. The agreement is void because it was tantamount to malpractice, which is the practice of soliciting cases at law for the purpose of gain, either personally or through paid agents or brokers. Malpractice ordinarily refers to any malfeasance or dereliction of duty committed by a lawyer. The practice of law is a profession, not a business. The lawyer may not seek or obtain employment by himself or through others, for to do so would be unprofessional. Tantec Bank versus Timoteo David. Use of disrespectful language in the pleadings. A lawyer is an officer of the courts. He is, like the court itself, an instrument or agency to advance the ends of justice. His duty is to uphold the dignity and authority of the courts, to which he owes fidelity, not to promote distrust in the administration of justice. It bears emphasis that the use in pleadings of language disrespectful to the court or containing offensive personalities serves no useful purpose and, on the contrary, constitutes direct contempt. In Re Rafael Climaco, 55-107. Use of intemperate language, respect for the judiciary. The court finds Attorney Sanko's remarks in his motion for reconsideration disparaging, intemperate, and uncalled for. His suggestions that the court might have been guilty of graft and corruption in acting on these cases are not only unbecoming, as well as an open assault upon the court's honor and integrity. In rendering its judgment, the court yielded to the records before it, and to the records alone, and not to outside influences, much less the influence of any of the parties. Attorney Sanko, as a former judge of an inferior court, should know better that in any litigation one party prevails, but his success will not justify indictments of bribery by the other party. He should be aware that because of his accusations, he has done an enormous disservice to the integrity of the highest tribunal and to the stability of the administration of justice in general. Attorney Sanko is entitled to his opinion, but not to a license to insult the court with derogatory statements and recourses to argumenta ad hominem. Attorney Sangalang et al. Versus Intermediate Appellate Court, August 13, 1989. Duty of attorney to be pure and to appear to be so. Court advises lawyers to be like Caesar's wife, to be pure and to appear to be so. This stern rule is designed not alone to prevent the dishonest practitioner from fraudulent conduct, but as well as to protect the honest lawyer from unfounded suspicion of unprofessional practice. It is founded on principles of public policy, on good taste. And has been said in another case, the question is not necessarily one of the rights of the parties, but as to whether the attorney has adhered to proper professional standard. With these thoughts in mind, it behooves attorneys like Caesar's wife not only to keep inviolate the client's confidence, but also to avoid the appearance of treachery and double dealing. Only thus can litigants be encouraged to entrust their secrets to their attorneys, which is of paramount importance in the administration of justice. Hilado versus David, 84 Field 571. Duty of attorney to honor his oath, effect of failure thereof. Attorneys are reminded of their solemn oath upon their admission to the Philippine bar, that they will do no falsehood and conduct themselves as lawyers according to the best of their knowledge and discretion, with all good fidelity to the courts and their clients. The unsatisfactory explanation given by Attorney Delantes against the pleadings of record in the case at bar evinces a willful disregard of his solemn duty as an attorney to employ in the conduct of a case such means only as are consistent with the truth and honor, and never seek to mislead the courts by an artifice or his false statement of facts or law. The court has ever stressed that a lawyer must do his best to honor his oath, as there would be a great detriment to, if not failure of, the administration of justice if courts could not rely on the submissions and representations made by lawyers in the conduct of a case. As stated by the court in one case, time and time again, lawyers have been admonished to remember that they are officers of the court, and that while they owe their clients the duty of complete fidelity and the utmost diligence, they are likewise held to strict accountability insofar as candor and honesty towards the court. Liberato Casals et al. Versus Honorable Vicente Cusi, July 12, 1973. Duty of the lawyer to obey lawful orders of the court. Consistent with respondent's failure to file an answer to the complaint herein filed against him, he also did not appear, despite due notice on the 4 occasions when the hearing of the present complaint was set at the office of the Solicitor General. Neither has respondent shown concern or interest about the status of the complaint filed against him. The inaction of respondent to the resolutions of this honorable court requiring him to file his answer to the complaint filed against him, and his subsequent failure to attend the hearings on the said complaint indicate that respondent has not obeyed the legal orders of the duly constituted authorities, and he has not conducted himself as a lawyer according to the best of his knowledge and discretion with all good fidelity as well as to the court as to his clients. Section 3, Rule 138, Rules of Court. Further, lawyers are particularly called upon to obey court's orders and processes. They should stand foremost in complying with the court's directives or instructions, being themselves officers of the court. This lack of concern shown by respondent regarding the matter that involved the very foundation of his right to engage in the practice of law would show how much less he would regard the interests of his client. Ngayon versus Tugate, 193 SCRA 779. Negligence of counsel. As a general rule, a client is bound by his counsel's conduct, negligence, and mistakes in handling the case during the trial. However, the rule admits of exceptions. A new trial may be granted where the incompetency of counsel is so great that the defendant is prejudiced and prevented from fairly presenting his defense. Where a case is not tried on the merits because of the negligence of counsel rather than the plaintiff, the case may be dismissed, but in the interest of justice, without prejudice to the filing of a new action. Clearly, petitioner was deprived of her right to present and prove her defense due to the negligence of her counsel. The appearance of a certain attorney Buen Zamar is of no moment, as there was no client-attorney relationship between him and the petitioner, who did not engage his services to represent her in said cases. The fact that notices of the promulgation of judgment were sent to the petitioner at her address of record produced no legal consequence because notice to a party is not effective notice in law. Romino Suarez versus Court of Appeals, 220 SCRA 274. Exception to the rule that mistake of the lawyer binds the client. While this court is cognizant of the rule that generally a client will suffer the consequences of the negligence, mistake, or lack of competence of his counsel, in the interests of justice and equity, exceptions may be made to such rule, in accordance with the facts and circumstances of each case. Adherence to the general rule would, in the instant case, result in the outright deprivation of their property through a technicality. The court finds that the negligence of counsel in this case appears to be so gross and inexcusable. This was compounded by the fact that after petitioner gave said counsel another chance to make up for his omission by asking him to file a petition for annulment of the judgment, in the appellate court, again, counsel abandoned the case of petitioner in that after he received a copy of the adverse judgment of the appellate court, he did not do anything to save the situation or inform his client of the judgment. He allowed the judgment to lapse and become final. Such reckless and gross negligence should not be allowed to bind the petitioner. Petitioner was thereby effectively deprived of her day in court. Victoria Ligarda versus Court of Appeals, 195 SCRA 418. Exception to the rule that a client is bound by the mistakes of his lawyer. Petitioner's right to appeal should not be lost through technicalities. His liberty is at stake. He faces a jail term of 17 years and 4 months to 20 years. If he has to spend this long stretch in prison, his guilt must be established beyond reasonable doubt. He cannot lose his liberty because of the gross irresponsibility of his lawyer. Losing liberty by default of an insensitive lawyer should be frowned upon despite the fiction that a client is bound by the mistakes of his lawyer. A. York, Aguilar versus Court of Appeals and the People of the Philippines, 250 Squa, 371. Duty of a lawyer to return the property of his client entrusted to him. A lawyer under his oath pledges himself not to delay any man for money or malice, and is bound to conduct himself with all good fidelity to his client. He is obligated to report promptly the money of his client that has come into his possession. He should not commingle it with his private property or use it for his personal purposes without his client's consent. He should maintain a reputation for honesty and fidelity to public trust. Fermina Legaspi de Roy et al. Versus Attorney Ramon Chavez Legaspi. Appearance of counsel. The appearance of a lawyer as counsel for a party and his participation in a case as such counsel does not make him a party to the action. The fact that he represents the interests of his client or that he acts in his behalf will not hold him liable for or make him entitled to any award that the court may adjudicate to the parties, other than his professional fees. The principle that a counterclaim cannot be filed against persons who are acting in representation of another in their individual capacities could be applied with more force and effect in the case of a counsel whose participation in the action is merely confined to the preparation of the defense of his client. Marcelo de Borja versus Juan de Borja. Substitution of attorneys requisites. The settled rule is that in order that there may be a valid substitution of attorneys in a given case, there must be a written application for substitution, b. a written consent of the client, and c. a written consent of the attorney to be substituted. In case the consent of the attorney to be substituted cannot be obtained, there must at least be proof that notice of the motion for substitution has been served upon him in the manner prescribed by the rules. In law, it is assumed prima facie that every attorney who appears in court does so with sufficient authority. The fact that a second attorney enters an appearance on behalf of a litigant does not authorize a presumption that the authority of the first attorney has been withdrawn. There is no question that a party may have two or more lawyers working in collaboration as his counsel is given litigation. Here, petitioner's counsel, Attorney Vasquez, not only affirmed his continued connection with the case, but also explained Attorney Hermosísima's appearance as collaborating counsel. While it may be desirable in the interest of an orderly conduct of judicial proceedings that a counsel for a party should file with the court his formal written appearance in the case before filing a pleading therein, or mention in said pleading that he is submitting the same in collaboration with the counsel of record, the mere circumstance that such acts were not done does not warrant the conclusion that the pleading filed by such counsel has no legal effect whatsoever. Ong Ching versus Honorable Jose Ramolete et al. 51 Squat 13. Withdrawal as counsel de officio. There was no incompatibility between the duty of petitioner to the accused and to the court and the performance of his task as an election registrar of the Commission on Elections, and that the ends of justice would be served by allowing and requiring Mr. Ledesma to continue as counsel de officio. Since the prosecution has already rested its case, the role of a member of the bar in the defense of an accused is indispensable. Such consideration could have sufficed for petitioner not being allowed to withdraw as counsel de officio. There are times, and this is one of them, when duty to court and to client takes precedence over the promptings of self-interest. Antonio de Ledesma versus Honorable Rafael Climaco. And by the way, I'm not claiming any rights on any material I turn into audios. These are materials downloadable online. If somehow these are helping you and you are not yet subscribed, go ahead and hit that subscribe button. It is free, and it makes me feel good about exerting all these efforts. Withdrawal of counsel. It is not disputed that the withdrawal of appearance of Attorney Jose Jimenez Jr. was filed with the trial court on February 12, 1991. Since the withdrawal was with the client's consent, no approval thereof by the trial court was required because the court approval is indispensable only if the withdrawal is without the client's consent. The retirement is completed once the withdrawal is filed in court. No further action thereon by the court is needed other than the mechanical act of the clerk of court of entering the name of the new counsel in the docket and of giving written notice thereof to the adverse party. The failure of the clerk of court to do either does not affect the validity of the retirement. The appearance of the new counsel, Attorney Pineda, did not likewise require the approval of the court. An appearance may be made by simply filing a formal motion, plea, or answer, or through the formal method, viz., by delivering to the clerk of court a written direction ordering him to enter the appearance of the counsel. The latter method is exactly what Attorney Pineda followed. Eloisa Arambolo et al. Versus Court of Appeals and Engineer Danilo Ferreras. Attorney's fees. When there was no express agreement between petitioner corpus and respondent David as regards attorney's fees, the facts of the case support the position of respondent David that there was at least an implied agreement for the payment of attorney's fees. Petitioner's act of giving the check of $2,000 to his April 18, 1962 letter to respondent David indicates petitioner's commitment to pay the former attorney's fees, which is stressed by expressing that I wish I could give more, but as you know, we were banking on a Supreme Court's decision reinstating me and reimbursing my back salaries. This last sentiment constituted a promise to pay more upon his reinstatement and payment of his back salaries. The absence of an express contract for attorney's fees between respondent David and petitioner corpus is no argument against the payment of the attorney's fees, considering their close relationship, which signifies mutual trust and confidence between them. Marina Corpus versus Court of Appeals and Juan T. David. Quantum merit. This court has repeatedly fixed counsel fees on a quantum merit basis whenever the fees stipulated appear excessive, unconscionable, or unreasonable, because a lawyer is primarily a court officer charged with the duty of assisting the court in administering impartial justice between the parties, and hence, his fees should be subject to judicial control. Nor it should be ignored that sound public policy demands that courts disregard stipulations for counsel fees whenever they appear to be a source of speculative profit at the expense of the debtor or mortgager. Baccarat versus Golinko, 39 Phil 139. Contingent fee contract. An attorney hired on a contingent arrangement and whose services were terminated by his clients because of his refusal to represent them in the out-of-court settlement of their claims has no right to interfere in the implementation of the settlement agreement in his efforts to collect attorney's fees not due him. Celia B. Chua et al. Versus National Labor Relations Commission, 190 SCRA 554. Retaining lien. Construing Section 37 of Rule 138 of the Revised Rules of Court, there is no question that a lawyer has a retaining lien upon the funds, documents, and papers of his client that may have lawfully come into his possession until his lawful fees are duly paid. However, where the appellant lawyer was appointed by the former administrator of the state, and such appointment was not in pursuance to any court order, nor was it approved by the probate court, it should be regarded as an act personal to the administrator. The creation of professional relationship between the appellant and the administrator did not, therefore, make the estate also a client of the said lawyer. Consequently, the appellant cannot claim to have a retaining lien over any funds, papers, or documents belonging to the state, even if these properties may have come into his possession in the course of his work as such counsel for the administrator. Testate estate of Amadeo Matute, re incident on the retaining lien of attorney Antonio Enrile Inton versus Julian Villanueva Matute. Integrated Bar of the Philippines. Membership in the Integrated Bar of the Philippines. To compel a lawyer to be a member of the Integrated Bar is not violative of the constitutional freedom to associate. A lawyer becomes a member of the bar when he passed the bar examinations. All that integration actually does is provide an official national organization for the well-defined but unorganized and incohesive group of which every lawyer is already a member. The Supreme Court, in order to further the state's legitimate interest in elevating the quality of professional legal services, may require that the cost of improving the profession in this fashion be shared by the subjects and beneficiaries of the regulatory program, the lawyers. In Re Attorney Marshall A. Edilon, 84 Scrap 554. Suspension and disbarment. That the misconduct committed by Attorney Almacen is of considerable gravity cannot be overemphasized. However, heeding the stem injunction that disbarment should never be decreed where a lesser sanction would accomplish the end desired, and believing that it may not perhaps be futile to hope that in the sober light of some future day, Attorney Almacen will realize that abrasive language never fails to do disservice to an advocate, and that in every effervescence of candor there is ample room for the added glow of respect. It is our view that suspension will suffice under the circumstances. His demonstrated persistence in his misconduct by neither manifesting repentance or offering apology therefore leave us no way of determining how long that suspension should last, and accordingly we are impelled to decree that the same should be indefinite. In Re Almacen 31 Scra 562. The power to disbar must be exercised with great caution. Only in a clear case of misconduct that seriously affects the standing and character of the lawyer as an officer of the court and member of the bar will disbarment be imposed as penalty. It should never be decreed where a lesser penalty such as temporary suspension would accomplish the end desired. Montano versus Integrated Bar of the Philippines. Duty and right of the court to institute upon its own motion suspension or disbarment proceedings when circumstances demand the filing thereof. It should be observed that the proceedings for the disbarment of member of the bar are not in any sense a civil action where there is a plaintiff and the respondent is a defendant. Disciplinary proceedings involve no private interest and afford no redress for private grievance. They are undertaken and prosecuted solely for the public welfare. They are undertaken for the purpose of preserving courts of justice from the official ministration of persons unfit to practice in them. The attorney is called to answer to the court for his conduct as an officer of the court. The complainant or the person who called the attention of the court to the attorney's alleged misconduct is in no sense a party and has generally no interest in the outcome except as all good citizens may have in the proper administration of justice. The court may therefore act upon its own motion and thus be the initiator of the proceedings, because obviously the court may investigate into the conduct of its own officers. Indeed, it is not only the right but the duty of the court to institute upon its own motion proper proceedings for the suspension or the disbarment of an attorney, where from information submitted to it or of its own knowledge it appears that any attorney has so conducted himself in a case pending before said court as to show that he is wanting in proper measure of respect for the court of which he is an officer, or is lacking in the good character essential to his continuance as an attorney. This is for the protection of the general public and to promote the purity of the administration of justice. Alfredo Tijan versus Honorable Vicente Cusi Jr. Propriety. The three meetings by Judge Abastillas with interested parties who had to stake on the outcome of the criminal case and the recorded telephone conversation where said cases were discussed manifested Judge Abastillas' willingness, nay propensity to enter into deals with motivation incongruous to the merits of the cases pending before him. Judge Abastillas committed serious misconduct no less. It is peculiarly essential that the system for establishing and dispensing justice be developed to a high degree of proficiency to gain the absolute confidence of the public in the integrity and impartiality of its administration, because appearance is as important as reality, so much so that a judge like Caesar's wife must not only be pure but beyond suspicion. Johnson Lee and Sonny Moreno versus Honorable Renato E. Abastillas, 234 Scra. 29. Inhibition of judges. Inhibition is not allowed at every instance that a friend, classmate, associate, or patron of a presiding judge appears before him as counsel for one of the parties to a case. Utang na loob per se should not be a hindrance to the administration of justice, nor should recognition of such value in Philippine society prevent the performance of one's duties as judge. However, where, as in this case, the judge admits that he may be suspected of surrendering to the persuasions of utang na loob, or he may even succumb to it, considering that he and the members of his family no less shall ever remain obliged in eternal gratitude to Justice Reyes. The negative answer to the question of Judge Elizaga yields to exceptions in extraordinary cases. Judges Macedao and Elizaga Ray Criminal Case number 4954-M. A judge may not be legally prohibited from sitting in the litigation. This one suggestion is made of record that he might be induced to act in favor of one party, or with bias or prejudice against the litigant arising out of circumstances reasonably capable of inciting such a state of mind. He should conduct a careful self-examination. He should exercise his discretion in a way that the people's faith in the courts of justice is not impaired. A salutary norm is that he reflect on the probability that a losing party might nurture at the back of his mind the thought that the judge had unmeritoriously tilted the scales of justice against him. That passion on the part of a judge may be generated because of serious charges of misconduct against him by a suitor or his counsel is not altogether remote. He is a man, subject to the frailties of other men. He should therefore exercise great care and caution before making up his mind to act or withdraw from a suit where the party or counsel is involved. He could in good grace inhibit himself where that case could be heard by another judge and where no appreciable prejudice would be occasioned to others involved thereon. On the result of his decisions to sit or not to sit may depend to a great extent that all-important confidence in the impartiality of the judiciary. If after reflection he should resolve to voluntarily desist from sitting in a case where his motives or fairness might be seriously impugned, his action is to be interpreted as giving meaning and substance to the second paragraph of Section 1, Rule 137. He serves the cause of the law who forestalls miscarriage of justice. Pimentel versus Salanga, 21 Scra. 160. Disqualification of judges. Attorney Calanog appears to be sincerely repentant. He describes the effect of the decision in this case as a healing surgery for him. Attorney Calanog is a relatively young man of 54. If his contributions during the 4 years that he was an RTC judge were any measure of his potentiality for public service, he has productive years still ahead of him, which should not be foreclosed. The penalty of disqualification from appointment to any public office should be lifted so that the opportunity for public service in other fields may be opened to him. His return to the judiciary may not be feasible at this time, considering the recency of our decision, but certainly in the vast field of public service, there should be room for the gainful employment of his talents. Indeed, in the past, this court showed compassion in imposing penalties, taking into account the peculiar circumstances of the case. M. Castillo versus Judge Manuel Calanog, Jr., 239 Scra. 268.